Morning, Your Honor.
Good morning, Travis. How are you?
I'm good. You can disregard that email.
Got a little ambitious, were we?
I was making sure we were on the same link.
Yep.
There we go. Had a little problem here, Your Honor. Got it under control now.
Let me see. Where, sorry about that. We're putting Zoom on YouTube also. Chris, can you hear me?
Yes, sir, I can.
Okay. Anticipating anybody else for today's purposes out of the council?
Not for me, Your Honor, just me.
Travis?
Your Honor.
Okay. We also got the recording going, 2017 CV118 Mid-Kansas Electric. Mike and Tina Andrew, other defendants. Council could have appearances, please.
Certainly, Your Honor. The plaintiff appears by and through Travis J. Turnus of Watkins Calcara Charter.
Your Honor, please, Chris McElgan appears on behalf of the defendants.
Thank you. Excuse me. We scheduled today for somewhat of a status hearing. The court brought a concern or two to council's attention earlier this week. We had a jury trial set commencing Tuesday. Mr. and Mrs. Andra requested a continuance based upon some family emergencies. Conferred with plaintiff's counsel. Plaintiff had no objection. Conferred with the court. Court had no objection. So the jury trial, came off the docket for this week. This weekend, I myself attended a benefit dinner, dance, and auction in Wichita, Kansas, and observed both Mike and Tina Andra at that event, conflicting with perhaps the information that was at least filed in the case in the motion for continuance. I verified that Monday morning prior to contacting counsel. It did say what I thought it had said as far as their timeline. So I brought that concern to counsel for any possible or plausible explanation. Council knows those concerns, and I'll ask Mr. McElgan of any new or more information might have been gleaned about your communication with your client or that communication with the court.
Yeah, yes, Your Honor. I followed up shortly after we had our last conference, talked to my client on the phone, got some additional information, and passed that on to Mr. Turnus, and then met with my client the next afternoon on this and the case in general. And I think, as the court noted, that there was always more information when things like this come to light. And I think the court's first concern is, from my notes, was giving us the very advanced notice of what you observed and your concerns, that there might be a need for you to recuse yourself if you had to essentially kind of take the role as a witness. There's absolutely no need for that. There is no dispute that about the Andres being present in Kansas and at the event on this past Saturday. To give you a little, to give you some more background, so I have more details, because I had not talked to the Andres until, or Mr. Andre, until Monday after our hearing, and so I had no information as to their return to Kansas. But the daughter-in-law is Emily Andre, who's ill. She's a school psychiatrist down in Florida, where she lives with Aaron Andre, Mr. and Mrs. Andre's third son, I believe is how they refer to him. And as I think I explained in general in the communications I had with the court leading up to continuing the trial, that they got information late that week, the fact that Emily had a fairly grim diagnosis for breast cancer and prognosis, and it became somewhat of a surprise. And under the circumstances, they had sent her home from the hospital where she was being evaluated, and there were a lot of family decisions, a lot of personal decisions that needed to be made financially, course of treatment, if any, how the kids were going to address it. They had nobody in Florida. So my clients were able, at least as far as flight connections, financial, those type of things, to get down to Florida as fast as they reasonably could to be with the kids, provide support, help them get the lay of the land, as I put it. And so that's the information I believe I got on Friday or Thursday night, or may have been Friday. Then I contacted Mr. Turnus. I believe it was the timing of that. They got the first flight available to Florida, which got them there early Sunday morning on the 6th. Again, the information that I received, he reconfirmed it. At that time, the diagnosis, the prognosis was pretty grim. And so when they got down there was a lot of unknown as to what was going to happen, and what was known wasn't really very positive. And that one of the problems is little or no treatment options. What options were there? What was she going to want to pursue? Insurance issues, and I'll explain that. But the Andres planned to stay as long as they needed to stay, and they anticipated that it would be into this week in conflict at trial. But their plan was to stay down there as long as they were needed. One unknown was at the time was when Emily's mother and sister, who she's very close with, could get down there to be with the kids and be with the Andres. They live. Her name's Jill Bliss. She lives in Iowa. Emily's father, I believe, he's a football coach. I believe a high school football coach, and she has sisters in the Kansas City area. And they were trying to get down there as quick as they could too. But the Andres could be down there faster under the circumstances. When the Andres got down there, it was a pretty challenging position. Apparently, their daughter-in-law was very upset. She holed up in her bedroom, wouldn't talk to anybody, wouldn't talk with Andres. And so it was a pretty emotional, challenging situation. But they're having to deal with all the things that Your Honor, I know, is familiar with, given your family issues, I think, that you mentioned. One of them was she cannot leave this school district for whatever reason, or cannot leave the area. She would be out of network in care and treatment. So they were trying to, that was all being considered and worked through. She was going to run out of her PTO in a couple of weeks and would have to go on COBRA, how they were going to fund that. And so they're just kind of treading water. It was the emotional nature or the challenging nature of the situation was pretty difficult. Mrs. Andre came back in the middle of the week because she just basically said, I can't really do this. This is too upsetting. What purpose are we serving? Those are my words, but I think that was some of it. And so Mike ended up getting her to be able to come back to Kansas the middle of the week. He stayed. Again, the plan was he's going to stay as long as he needed, and as long as Aaron wanted him to stay. Ultimately, Mrs. Bliss was able to get down to Florida, I think, with one of the sisters who lives in the Kansas City area. And again, Mr. Andre planned on staying just to help Aaron, be there for Aaron, his son, whatever needed to be done. It was a fluid situation. So Aaron ultimately told him on Thursday or Friday, hey, it's okay, Dad, I'm going to be okay. She's got her sisters and her sister and her mother here. That's who she wants to deal with. You've been a good help. It's okay. You go on back. I'll be fine. And, you're probably going to have to come back at some point in the future anyway. So he was able at that time to come back, get a flight, come back on Friday. So the information that we provided was that I provided was the information that I knew at the time. And again, my clients not having a full appreciation of what they're going to be up against, how this was going to unfold. We're operating on the best information that he had at the time when he contacted me, and things again developed that week where there wasn't an emergent need to have them down there. It didn't make much sense, and would have to go back down. And so with those late events, he came back. He came back. No dispute on that. He didn't contact me on Saturday. From his perspective, you know, it's just unfolding as it unfolded. The trial had been continued. It was a weekend. He hadn't contacted me. If I would have known on Friday, I would have kept everybody apprised as to what the status was. From my perspective, I think I had to move fast because I really didn't want to wait any later. Not that I thought I needed to, but because we're into the last week of trial preparation and didn't want to come down and say, hey, he's definitely, this is what the deal is, and is what we thought it was going to be. And he is or isn't going to be at trial, because it will be a waste of counsel's time and witness preparation and those type of things. So I never gave it any other thought based upon the information that I had and what the information my client had at the time, that there was any expectation that he would be back and be able to attend trial, would even be here for trial. And that's how that's how the situation unfolded. I'm looking at my notes here, Your Honor, forgive me.
Sure.
You know, the one thing, and so full transparency, obviously always from my perspective,
Yes,
that's the situation that unfolded. And it wasn't any intent to somehow finagle on my client, to finagle a continuance based upon some type of representations that he knew to be false at the time. The lawyer in me, the advocate in me says, hey, looking at the situation, if he was really trying to pull the wool over everybody's eyes to get a continuance, he sure wouldn't have showed up on Saturday at a very well-attended public event where people would know him. He made no effort to hide himself. People in the community that know him were there. I think he mentioned to me that the ACOX were there, and they were parties involved in that other case that was before Your Honor. But anyway, that is the explanation that I have is that he operated on gave me the best information that he had. Needed to adjust the schedule. Things changed very quickly or developed really quickly into the weekend, and that's what led to him being present. He was one of the reasons why he did go, as I understand it, not knowing all the businesses and things that are involved. He did go to the event because before this all occurred, he had planned to go to the event. Plus, I believe, I don't know if it's one of the radio stations or the venue that he owns, there was some connection to the band that was there or something like that he felt like and had felt like he needed to be there, and may have been asked to be there by the people putting on the event. But I'm a little vague on that. I'm not sure because I don't know the parties, but that was the information that I got from Mr. Andre. So any questions or anything else I need to address, I stand ready. I can go out and get more information if you would like, but that's the facts.
And so I'll give Mr. Turnus an opportunity here just shortly. I wanted to follow up, and both counsel recognize, I think I fully admitted, I wasn't sure quite how to handle this, and I knew there would have to be some sort of explanation for the events. The thought in my mind was the worst thing I could do was not address it with counsel. Both counsel acknowledged that we kind of went through that on Monday.
Yes, Your Honor.
Yes.
I wasn't being accusatory by any means. It was merely catch us all up, perhaps.
And Your Honor, forgive me. I'm sorry to interrupt. I never took that to be where you were coming from. So,
And to clarify, if you said ACOGs, if they were at the event, I didn't see them or notice them. Certainly had no communications with anybody, to include Mr. Andra. But to clarify, that case is over.
right.
That was settled out of court prior to imposition of contempts and things like that. I believe it. And correct me if I'm wrong, Mr. McElgan, but I want to make sure that that issue's over with, and there weren't any current other litigants that at least were brought to light for you that I knew about.
No, Your Honor, and that wasn't probably something I didn't. It was just his reaction was, yeah, everybody was there. I even saw these guys because he knew that I knew who they were, and it wasn't any. There's nothing involved in that case that has anything to do with this case. It was just the narrative that I received from him.
Yes, sir. Let's see. And so it's your position, Mr. McElgan, and that of your clients. There is no request for me to recuse for any purpose in this case against Mid-Kansas.
Two prongs on that. I think the first concern were these events. No issue there. As I understand, as you expressed, there were some campaign issues. And that I was barely generally familiar with,
Sure.
But the position on that, or the consideration, is that, Judge, you're in the best position to determine, and if you're comfortable, we're comfortable, and we're not raising it as an issue.
Okay. And yeah, I may have cut you off before you wanted to finish your thoughts on that. And I said also on Monday, I appreciate and respect the political process. I take no quarrels with it. I knew it would come down to whether I'm comfortable enough to continue sitting on the case. And I only brought that issue up because I didn't want to explore and go through perhaps the Saturday evening event issue, get through that, and then this hard feelings or wherever your clients stand on the radio ad to be thrown in after the fact. I wanted it to be handled completely, which we're doing. Your information, Mr. McElgan, about I know that's a fluid situation, as you pointed out, very sensitive situation, as I've gone through, and you pointed that out as well. When they might have to go back in the future, we already talked about some time might be appropriate on this case before setting another trial. We will be into 2023. Your thoughts as to perhaps what we should be looking for, what you might be looking for your client's timeline.
From my perspective, thinking about that, Your Honor, I would think that, and of course, defer to the realities of scheduling, but it seemed to me that under the circumstances, I think sooner, as opposed to in your calendar and in Mr. Turnus's calendar, maybe January, mid-January, something like that. But I think that at this point in time, knowing more as to what is the actual family situation, I'm comfortable with that. Now, if we get into the spring, I think we'll be okay too to plan around it, but I would need to go back and make further inquiry. But I think that based upon my conversation is that if you set it in January, early February, we should be okay.
Okay.
But again, we were the ones that requested under the circumstances, requested the at least this continuance, and understand that sometimes you got to juggle things. From my perspective as a lawyer, it's easier for me to deal and react when I know that in managed scheduling, when we have a full appreciation that, hey, this is an issue out there, so we need to prepare to, if you need to come back and forth or something like that, we can deal with it.
Okay. And two final points. I wanted to make sure I clarified. I started out my comments on Monday not being critical of either council, certainly, and because it revolves around Mr. McElgan's representations to the court. I can't stress that enough, that I wasn't being critical, and you've laid out just a phenomenal explanation about how to handle situations like that. So still not being critical, have not been critical, and we won't hold it against one side or the other. It's
Thank you, Judge.
something people have to go through. My thoughts, and then I'm going to turn to Travis. My thoughts would be still put it for a status on one of my civil motion days, either December 6th or January 10th. And then on those, whatever date we pick, then schedule the jury trial. That will allow a couple things, a little bit of time, but plus for the Andrews to comprehend what they might be doing between Kansas and Florida before we set the jury trial date. Travis?
Explanation makes sense to me, Your Honor. Skeptic by nature, but all we need is a jury trial reset. It is what it is. Not happy I got a third continuance, but life happens and I get it.
Sure, understood. Has between December 6th and January 10th, any preference? And again, I understand both council's comments. I'm not necessarily in a rush to get that on and scheduled. Working off my phone today for calendaring. I mean, I think we had one more mid-Kansas trial in March or April, but I have some time after January to schedule it.
Travis?
So between those two dates, let's not pick jury trial today. Let's pick between those two dates, and we'll come back fresh and pick calendars.
If we could do sometime on December 6th, that would be my preference.
Okay, Mr. McElgan?
That would be my preference also, Your Honor, because sooner, for me, on my side, the sooner I can address all this and get something in place so I can deal with my clients, and the better it's going to be.
Okay. 11 or 11:30 work for council on December 6th?
Either one.
Yes, Your Honor.
Okay. Let's go 11:30 a.m. by Zoom, same link, same passcode. We need to follow the motion for continuance up with an order showing that date and time for status or scheduling conference. And then any pretrial documents that need to be updated or amended, you might go through those and you can get those as well. Anything else for today? Anything else you'd like to put on the record, Mr. McElgan?
Other than I appreciate the court and council's patience and understanding, and I'm glad that I was able to get the information in front of you, and both of you have been very, very kind and understanding. I appreciate it.
I apologize catching you cold on Monday. Just as I said, new to the bench, not had that situation, didn't know quite what to do, but I knew what I shouldn't do was not address it. Thank you for your time and effort this week. Mr. Turnus?
Nothing further, Your Honor.
All right, December 6th, 11:30 by Zoom. We'll pick jury trial sometime in 2023.
Thank you, Judge.
Thank you both for your time this morning. Have a great weekend.
Thank you, Your Honor.
Happy holidays as well.
Gotcha. Bye-bye.